I'm Charlie from Sweeney and met quite a few of you before. I particularly handle litigation matters, so I've acted for a few people with regards to tenant evictions, possessions, and I spoke previously in the year generally about the Renters' Rights Bill, and now that the scope of it's coming to fruition, I just wanted to talk about a few of the finer points. So where we're at the minute, so as of today, the bill is still in Parliament. It's at the Lords in the committee stage. The next step is the report stage. I think we're still waiting a date for that. It'll then proceed to what's called the third reading, and then ultimately it will return to the House of Commons, who will consider the amendments of the Lords. It's planned that it will come through by the summer, so July 2025 is the plan, which is a year from when Labour got elected, and then although that will be when royal assent will apply, there's still a bit of it's still rumours as to when most or some of the legislation will actually come into practice. So there's phased elements to some extent, which we'll come on to. So it might actually extend into 2026 for the full effects. One of the issues that I'm going to discuss is student lets. I know quite a few people in the audience have got student lets in and around Newcastle, in Jesmond, etc. So one of the major changes with regards to the bill is the open-ended nature of tenancy. So it's no longer going to be standard practice that residential tenancy agreements are for fixed terms. So after the implementation period, most properties will be subject to periodic tenancies that go on month to month. It's on the principle behind it and the headlines that you'll read is that this is supposed to support tenants, but realistically it might actually hamper tenants, because with that uncertainty, which I'll come on to about the new cohort of tenants in the student market year to year, it makes it all uncertain, added regulation, so it might actually drive landlords away from student properties and in effect ramp up the rental prices. With regards to student lets, to address concerns with that, the government's introducing a new ground for possession, so it's ground 4A. It's a mandatory ground, and it applies to HMOs in line with the academic cycle. So under this ground, landlords can seek possession between 1st of June and 30th of September, provided that they've given written notice to rely on it. So basically it's got to be in the tenancy agreement itself that the landlord might rely on this ground later. It's limited in scope. Like I say, it applies only to HMOs, let the full-time students, and it excludes 1 and 2 bedroom flats. So there's been a lot of consultation about that. It's quite controversial because I think roughly a third of all student lets are within that category. So a lot of the 1 to 2 bed properties will fall outside of that, and you won't be able to rely on this ground. The exclusions raise concerns among landlords and industry bodies, like I say, about potential reductions in available student housing. It's more rules, it's ultimately more admin, more costs for the landlords, and the tenants, like I say, will face the foot of that. There's a risk that these changes will drive some landlords out, like I say, out of the student market entirely, and there'll be ultimately fewer properties. Here's an example, because I know it's quite technical, but here's an example of how that would work. So if a landlord will have a 5-bedroom HMO in a university town, lets the property to 5 full-time students, the tenancy will begin 1st of September. Like I say, with the new cohort of students coming in, the landlord would like possession by the following year in the June, so it can re-let to the next year's students. So before that tenancy starts, like I said, the landlord's got to give the tenants written notice to rely on that ground. So obviously minded that with the changes coming in the summer, it's got to be expressly stated in the tenancy agreement itself, so that's important. The tenancy agreement is signed in April 2025, so again, bit of a technicality, but to rely on this ground, the tenancy has got to start within 6 months of when it's signed. So obviously in this example, September 2025, this one's signed in April 2025, so that'll comply with the bill. Fast forward to the next year, so in April 2026, the landlord decides to repossess the property for the next student group. So she'll serve a Section 8 notice relying on ground 4A, and with that there's a 2-month notice period. The notice will state that she intends to regain possession on the 30th of June 2026, so that ties in with the student break-up year. Practically speaking, obviously, if there's an issue with the tenant and ultimately the landlord needs to go to court to get possession on this ground, it's going to be practically very difficult. So that's another implication of this, because obviously the time it'll take you to go through court, it'll already be into the next academic year. But that's another issue in itself, which I'll come on to with regards to the courts. Purpose-built student accommodation, so PBSA, is another exemption from this. So that'll typically be, your high-rise kind of flats where it's just student letting. So they will be allowed to have those fixed-term tenancy agreements still. Those bodies, though, the PBSA providers, must be registered with a government-approved code of management practice, as noted there, to qualify. Another issue which will be presented by the bill is the prohibition on requesting more than 1 month's rent in advance. So that's quite a change from the current landscape. Again, the headline is it's to alleviate financial pressure on tenants to strike a balance between landlords and tenants. There's concerns, particularly with regards to international students, those who don't have a UK credit history, don't have a guarantor. It's going to be very unlikely that those international students will be able to obtain housing if the month in advance is limited to 1 month, like I say. So yeah, it could hinder their access to properties in the UK. As of now, the bill doesn't include specific exemptions for students, and that's one of the controversial points. Another matter that's raised quite a bit is rent increases with regards to the new legislation. So it's one of the most significant and underappreciated shifts in this bill, because it's obviously ties in with Section 21 going, and it'll reshape how landlords can manage that. So with Section 21 going, landlords will no longer be able to end the tenancy simply because a tenant rejects a rent increase. Now, I know that's probably quite rare in practice, and I rarely see that, but obviously it is a whole change there. Instead, rents are going to be regulated through a statutory process tied to market rates. So it will empower the tenants to challenge proposed increases at tribunal. What that means is rent setting, you'll have to take greater care, provide evidence, strategise it, note key dates as to when they can be increased, and obviously need to adapt quickly to avoid being blocked out to raise the rent. The current position is that you can raise rents in accordance with the express clauses of the tenancy agreement, or by way of the current statutory procedure, which is Section 13 of the Housing Act. There's a 1-month notice period for when the new rent will come into place. The tenant can challenge it at tribunal now, but there's little emphasis on the landlord initially to justify what it's proposing, basically, and that happens at the tribunal. The new bill introduces tighter controls on that. Obviously, most will be periodic tenancies. Rent can only be increased every 12 months and must be done through the prescribed process. and there's now a 2-month notice period, so it's doubled the period of time for when the new proposed rent can come into play. The tenant can have the right to challenge any proposed increase through the first tier tribunal if they think it's excessive. So, I expect that will be quite a lot. They may as well have a go at it. They've got 2 months, but the important point is that if they do challenge it, the last point there, if they do challenge it, it freezes the rent increase until the tribunal makes its decision. So I'm expecting quite a few appeals to the tribunal. They're going to be overwhelmed with those, I suspect. And like I say, tenants are likely just going to have a go for the sake of it. What's the worst that can happen? So like I've said, landlords should review their processes, ensure rent reviews are diarised. What's really important is that you're going to have the point there about the new market rate standard. You're going to have to rely much more on actual evidence rather than just plucking a figure out the air. I know that's probably quite rare in practice, but the tribunal will expect information and comparables as to why you've done that. And like I say, there's no use of Section 21s to circumvent it now, or when the new legislation comes in. Court delays, again, obviously being a solicitor, this is very topical, and it's always in the press about improvements of the county courts in particular, bailiffs. I spoke about it last time. Without Section 21, there's going to have to be a valid reason to evict the tenant, be that you want to sell the property, rent arrears, antisocial behaviour. So what that means is there's going to be a lot more hearings, there's going to be a lot more evidence, judges' time is going to be limited. As it stands now, you can issue a Section 21 claim accelerated, and then if you've got all the documents in place, there's no need for a hearing, it just gets accepted on the papers. That's not going to be possible now. There's generally longer notice periods. So for arrears at the moment, it's 2 weeks notice if there's 2 months arrears. It's going to 4 weeks. So again, that's going to delay the time that you get to court. If you want to regain possession, to sell or move back into the property, you'll need to give 4 months notice, and you can't do it in the first year. Some statistics. So in the first quarter of 2025, the average time between starting your claim and getting possession is 7 months. So that might be skewed because it takes generally a bit longer down south, but 7 months, if you said that to the layman, it would seem excessive, but that's the amount of time. And when it's on the basis of rent arrears, obviously that's particularly more frustrating because arrears generally will build up and up over those 7 months. And that's despite ministers, like I say, repeatedly claiming the courts are ready to deal with this change in the law. Recent NRLA survey of 1,400 landlords found that 96% lack faith in the courts. So that's a strong indication in itself. Like I said, bailiffs struggling with the backlogs. There's not enough district judge to cope with the number of hearings. And anecdotally, when I speak to landlords, they're kind of dissatisfied with the status. In quarter 4 of last year, there was 30,000 possession claims across England and Wales, and that's 8% increase from the same quarter the year before. So obviously it's indicative of landlords looking to evict certain tenants before the changes come in and use Section 21. The number of Section 21 notices filed in 2024 was 32,287, the highest in 8 years. 8 years ago was the Deregulation Act when there was further changes coming in, so there's clearly a trend there. And obviously without addressing these systematic issues in the public services, it's going to undermine the changes that are supposed to help landlords, well, particularly tenants. So there's a key issue there. That's my data. I think now, just generally speaking, it's a really important time with the changes coming in. Obviously, have a good agent, but also to take legal advice generally with all of the advent of new changes coming in. So it's particularly important.